This lazy father got aggressive when his sick wife asked for help with their child, so the judge held him responsible.
So what was this argument about?
I can't even remember that day.
According to the stipulations, the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. You hit her in her chest, then placed your hands around her neck. Her. So you don't remember any of that?
No, Your Honor, I was putting my daughter to sleep that night and she had been in the restroom. I was having difficulty putting my daughter to sleep and I had asked her to help me. I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical.
Well, it says here, the victim stated that she was strangled by her boyfriend. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location. All right. Well, in the report, they make it seem as though you her and then you cut your hair and then you left. The court will sentence you to 6 years in the prison. All right. Court is calling 2024 CR 00899. State versus Noel Anthony Rodriguez. Mr. Rodriguez, if you'll come down, if I could have parties announced for the record for the state.
Robert Robach for Noel Rodriguez.
And are you Mr. Rodriguez? All right, you entered a no contest plea on October 16th, 2024 to the offense of according to your plea bargain agreement. Punishment is to be assessed at a cap of 10 years in the prison. The state opposes your application. They're taking in consideration 2024 CR 008862. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, ma'am.
Any objections to the PSI report, state?
No objection.
No
Defense?
objections, Your Honor.
Have both parties had a chance to review the TAP evaluation, state?
Yes.
Defense?
Yes, ma'am.
Any objection to the TAP evaluation, state?
No objection.
Defense?
No objections.
Any witnesses, state?
No witnesses, Judge.
Defense, any witnesses?
No, ma'am.
All right. I'll hear argument then. State you're opposed?
We are, Judge. Given the defendant's criminal history, this is not the first felony that he's been committed or that's been convicted of. He has committed multiple acts of family violence, and one in October of 2023 was a strangulation. However, that case was dismissed because the complainant waived prosecution.
And who was the complainant in that case?
It would have to check actually, Judge. He has been convicted of unlawful carry of weapon and assault in 2021, and I can check the victim on that one momentarily. He also has been convicted out of state, out of Wilson County, for an assault second. He was given probation in that case. However, he did not complete his probation. He was revoked on December of 2023. And he is pleading to one case, which is the offense date of the 6th of June of 2024. It wasn't until he bonded out 3 days later, he committed another offense on June the 9th of 2024, also an assault second. Given his criminal history, given the fact that he has been given an opportunity to get probation in Wilson County, it has been revoked. The state does not believe that he would be a good candidate for probation, and we ask that you sentence him to no more than 10 years TBC.
Right. And while the state is finding the list of the complainant on the other cases, defense, I'll hear your argument.
Yes, Judge, defendant's been in custody for 168 days. He has no felony convictions that I know of. He has 2 children. He does need some mental health assessment. The complainant in the case, Megan Rodriguez, in the report states that she's in favor of probation. I think with the proper guidelines set forth and conditions that the probation recommends that he's learned his lesson. He's taken anger management courses, 12 of them. I'd like to give you copies
Any
of
objection
those.
to the court reviewing the certificates?
No objection.
So has spent his 168 days productively. in custody and is ready to return. He has to support his two children, needs to get back to work. And I think that any other conditions that you might give him that are outlined in the probation report, he's willing to follow follow your rules and not come back here.
All right, defense. I'm sorry, state.
Judge, to answer your previous questions on the first assault, the misdemeanor conviction was a different complainant. On the assault, strangulation that occurred on October 26th of 2023, where the case was dismissed for complaining waiving prosecution, was the same complainant as this case. It has a different last name, but I confirm it's the same date of birth.
All right, and then the case that you're taking in consideration, the ABI second, who's the complainant?
That one should also be the same.
All right, is there anything you wish to say?
I'm very more.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. All right, so what was this argument about?
I can't even remember that day.
All right, because according to the stipulations, it states that the complainant was sick through food poisoning, and she asked for your help caring for your child, which was crying. And it says that you became angry with her. So she ended up taking the child and asked you to fix a bottle for the baby. You were still angry and you were upset with her requests. So she put the child down and went to get the bottle for herself. You wanted to leave the residence and tried to get the car keys. She would not give you the car keys, so you slapped her. She defended herself. You hit her in her chest, then placed your hands around her neck. Her. So you don't remember any of that?
No, Your Honor. I was putting my daughter to sleep that night, and she had been in the restroom. I was having difficulty putting my daughter to sleep, and I had asked her to help me. She ended up picking up our daughter, and she started rocking her, putting her to sleep. After that, I was frustrated, but I wasn't trying to leave at that point. It wasn't until she had started getting physical that I was trying to leave. But at no point did.
Well, it says here, the victim stated that she was strangled by her boyfriend. She sustained injuries to her neck and chest. While speaking with the victim, I observed scratch marks and redness to the left and right side of the neck and redness to the chest. I observed bruising to the left and right biceps and underneath both arms of the victim. And they photographed the injuries. I also photographed a large amount of black curly hair clippings that were in the bathroom allegedly left by the suspect prior to him fleeing the location.
I had cut my hair that day.
All right. Well, in the report, they make it seem as though you her and then you cut your hair and then you left.
That day, it's hard to recall that day, but I know that when she had started me, and
Oh, so you're saying she started you first?
yes, ma'am.
Okay. You may continue.
After that is I started going back at her, and I regret it deeply. It's just
Okay. All right. Any questions?
No, Your Honor.
State any questions?
Just a couple, Your Honor. Mr. Rodriguez, you are applying for probation, or you're asking the court for probation. Okay. So you understand that the first step of probation is accepting responsibility, right? But when you spoke with the probation officer, when this report was being prepared, he did not want to talk about the incident, right?
I told the probation officer I couldn't recall it fully.
Okay, so you did say that you had difficulty remembering, but then you also said that you'd rather not talk.
I didn't want to talk about it without remembering it fully.
Okay, but you do remember that she started it?
Yes, sir.
Okay. How is that accepting responsibility if you're blaming it on her?
I'm taking responsibility for my actions. I shouldn't have reacted the way that I did. I should just walked out of the house once things started getting physical.
But you understand that you've been placed on probation before, right?
Yes.
And the idea is probation should give you the opportunity to rehabilitate yourself and avoid engaging in any more criminal behavior, right?
Yes, sir.
So you didn't complete probation in Wilson County, right?
No, sir.
Okay, and then you committed an offense on June the 6th, right? Of 2024? The choking?
Yes, sir.
And then again on June the 9th of 2024, right?
Yes, sir. Or June 9th. That day I didn't really do anything. I had OD and my wife had called the saying that she needed ambulance.
No further questions, Judge.
All right, anything else from the
No, I
defense?
think, Judge, the fact that he took these anger management courses shows that he wants to comply with the terms of probation if you give it to him.
All right, the court is going to deny your application, find you guilty. Does anyone wish to speak to the cap?
Judge, in light of the fact he has two children and he has a household that needs him, we request the cap be the minimum of 2 years.
All right, state, what are you requesting?
That's no more than 10 years.
All right. Mr. Rodriguez, I want you to know that I listened to the arguments of both sides. I listened to your testimony. I read the stipulations again because I'm not the one who accepted this plea. And I also reviewed the TAP evaluation and I reviewed the PSI report. This is what the court is going to do. Court is finding you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. Taking consideration 2024 CR 008862, there's to be no contact with Megan Lindsay Garza, no unsupervised contacts with minors. I'll recommend the therapeutic community for you. The therapeutic community does not increase the amount of time that you serve. For example, if I were to send you to 10 years, the fact that you're in the therapeutic community will not extend you beyond my sentence. Do you understand?
Yes, sir.
I do not have jurisdiction to force them to place you in the therapeutic community, so you'll have to request it. But it will show in your judgment that the court is requesting the therapeutic community for you to address any or alcohol issue or any mental health issues. And the court will sentence you to 6 years in the prison. Did you review the document? Yes?
Would it be possible
Yeah.
to get the no contact order dropped?
No. And let me explain to you why. I don't like for people to think that I just do things just to do things. For example, because 6 years instead of 10, there's a reason for that. I took in consideration the mitigation evidence. I took into consideration what the complainant wanted, and I took into consideration your criminal history, and I took into consideration the classes that you completed. With regards to the no contact order, there's an issue here. And that issue hasn't been solved because this is not the first time that you were accused of assaulting her. This is the first time that I guess she's given a statement to the police about it and come to court about it and continued with it. So obviously that relationship is not working. I don't have you on supervision with the court because I'm sending you to prison. If I had you on supervision, I would still have the no contact order, then maybe slowly consider lifting the no contact order. But not in this case, the answer will be no. All right, so that's 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
You signed.
Yes. Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know 6 years is a lot of time. It's a lot of time away from your children, but you can't continue to commit actions that you commit, violent actions, and then not expect there to be any consequences. When you're released from prison, if I'm still here, you need to make sure that you take care of your issues and you take care of your mental health issues. If you cannot find a place, come back here and I will pick up the phone and call someone to help you. You understand?
Upon my release, I plan on going to CHCS, Center for Healthcare Services.
Okay,
So
that's
that way I can
great.
Get my primary care doctor back on medication.
All right, awesome. Make sure that you stay on top of that, okay? Up to you.
Thank you, Judge.
Thank you.
This troubled daughter pleaded for a second chance and hopes to avoid a felony conviction, so the judge listened to her mother's heartfelt testimony.
I'm looking at her criminal history. She's been on deferred adjudication before, and that deferred adjudication was revoked, and she was given 44 days in the Bexar County Jail. So why should I grant her deferred adjudication? She's been given deferred before.
When I got put on deferred adjudication the last time, I was very young and I was freshly new into my and didn't know as much as I know about myself now. And I wasn't willing to do the work that I am willing to do now.
You want to call mom? Just before we start, I want you to know your testimony. If I don't give her deferred, it's not your fault. If I do give her your deferred, so there is no need for you. Every answer that you give me is the correct answer. When she was in her in the past, were you able to notice changes and could you tell that there were issues?
I am a registered nurse and there are times when I've seen it, yes.
So you would
In the
be able to
past.
know if there are some issues if she were falling off her schedule.
Oh, yes, ma'am.
And if she were to fall off her schedules.
And she's out of my house.
All right. Court is going to sentence you to 6 years deferred adjudication.